is not about name, image, and likeness. We're hearing a lot about name, image, and likeness these days. Don't confuse the two is a starting point. Name, image, and likeness involves a separate area of law, specifically the right of publicity and intellectual property law. This case is about antitrust law, and it's about how colleges, through the NCAA and conferences to some degree, restrict what college athletes can get paid, very basically. This case began 8 years ago. And when it began, it was a bigger deal, in essence, because it was about taking on NCAA restrictions that govern college athletes in terms of athletics, in terms of academics. At least initially, it was thought that the case could lead to a free agency of sort for college recruits. So if Zion Williamson had Duke, UNC, Georgetown, name your pick, recruiting him as a high school player, it could have offered him a scholarship, maybe hundreds of thousands or more in terms of the value. That was the argument. And the core argument was that why is it that when schools compete for coaches, when they compete for athletic facilities, when they compete for faculty, they can offer conceivably as much as possible. Yet with athletes, there's a restriction called the grant and aid. The grant and aid is a concept that limits what college athletes can get in a scholarship and through other concepts. So the case was taking it on, saying, this is unfair, this is illegal under antitrust law. Antitrust law requires competing businesses, which include colleges, from joining hands to restrain competition in unreasonable ways. So that was the basic argument, because the lawyers for Alston said, wait a second, if colleges could compete, they wouldn't be spending all this money on coaches, because they're spending money on coaches. They're spending money on facilities because they can't pay the players. That was the central thesis. Fast forward about 5 years later, and that was largely dismantled. Judge Wilkin in California, and then the Ninth Circuit out in California as well, held, well, we don't quite go as far as Alston wants. What we think is correct is that when schools join hands, they shouldn't be able to limit education-related expenses to college athletes. So the computer fee, potentially internships, other things, and what remains to be seen what those things are in terms of what colleges provide college athletes. And the Supreme Court agreed. Today, Justice Gorsuch, on behalf of a unanimous court, held it is illegal for the NCAA and its member schools, which again are competing businesses, when they join hands to limit what each can pay college athletes in terms of academic-related expenses, they are price fixing illegally. They are literally setting the price at the value of these benefits. In a more competitive market, schools could pay the players more for education-related expenses. And we should have schools competing with one another over this concept. Maybe there are opportunities where academics related to athletics, athletes could be enhanced. Let the schools figure it out. Let the free market decide what that ought to be. Now, the NCAA has argued, everything I just said, I have it wrong. The NCAA has argued what makes college sports attractive to consumers is that they're not paid. Literally, that's a key argument, that college athletes are amateurs. You can put an asterisk next to that, but we'll use that word for a second, that they're amateurs, that what makes college sports appealing to fans and that has engendered loyalty over decades for fans of different teams is that the athletes are not paid, that they're college students who happen to play a sport. And the NCAA has said, once we leave that model, once we allow college athletes to get paid in some kind of marketplace where schools could pay more, though they don't have to, fans are going to leave. Fans are going to view college sports like a glorified minor leagues. It's going to be like the G League on steroids, except across the country. No one's going to find it interesting. Justice Gorsuch today said that's not what this court is saying. The court is saying very simply that when there are restrictions related to academic-related expenses, that schools shouldn't cap what they can pay. The court was clear in saying, in terms of what college athletes can get paid regarding sports, the NCAA can continue to limit those expenses. So that was a key point. Now, in a concurring opinion, which is not precedent, so to be clear, this is not the law of the land, but in a concurring opinion, it's certainly persuasive, Justice Kavanaugh said the court hasn't gone far enough. the court should repudiate really all aspects of amateurism, that it is a scam, it's price fixing, it's a cartel. And he noted a number of examples where what happens if law firms got together to say, we're all going to agree to only pay associates, new lawyers, a certain amount of money out of the love of the law? Or if media companies got together to say, reporters can't get paid more than a certain amount because we want to focus on the love of journalism, that would also be illegal price fixing. He also used nurses as an example. If hospitals got together to say, let's limit what they can get because healthcare is really about a moral duty, all of that rhetoric, he said, we would immediately reject. So why is it that we don't reject it with college sports? Why is it that we say with college athletes, they need to be pure in some form? Let alone, as Justice Gorsuch noted in the opinion, college administrators of sports are paid a lot of money. If it was really the purity of the sport, presumably they wouldn't be paid so much, some of these coaches. And yet that goes to Alston's argument, because Alston's argument was what the NCAA has done is prevent what college athletes can get so that money gravitates to those around the athlete, the coach, the athletic director, the staff, the people who build athletic facilities and stadiums and world-class training centers. They're getting that money because it can't go to the athletes. So what does this mean going forward? Well, for one, it means that the NCAA is going to have to revise rules. The Supreme Court was clear in saying restrictions on what college athletes can get regarding academic-related expenses and benefits have to be lifted. So the NCAA will have to amend its rule book. It may have to excise certain rules. That doesn't mean the NCAA is going to throw amateurism out the water. That's not what the ruling is. The ruling is about academic-related expenses. Now, some of the justices worried that when you say academic-related expenses, schools are going to become creative. They're going to label things academics when they're really athletics. There was an example where a Lamborghini going to a college student could be labeled an academic-related expense. Justice Gorsuch said, please, don't bother us with hysterics. That doesn't make any sense. The court was clear in saying the Supreme Court preserves autonomy over athletic-related expenses. So boosters paying college athletes, sneaker companies signing them to endorsement deals, that would be illegal under amateurism, though I'll get to NIL in a second, where it might be legal under a different vehicle. But for now, that's not permitted by the ruling. So to be clear, the ruling is about study abroad programs, computer fees, also money that is awarded to athletes for meeting certain academic benchmarks, including GPA. Those, at least as it's worded, would be allowed, and it's up to about $6,000 a year to college athletes. The NCAA has said, well, that's tantamount to making them pros. The Supreme Court said, no, it isn't. $6,000 a year, that's not a professional athlete. It's not a wage because it isn't being negotiated. So a lot of the NCAA's arguments, the court really swiftly rejected. So going forward, the NCAA will have to change some rules. Here's the big thing going forward, though. Get ready for more lawsuits, because it's clear the Supreme Court is skeptical about the underlying arguments for amateurism. I don't think any reading other than a plausible one of Justice Gorsuch's opinion, and especially Justice Kavanaugh's concurring opinion, would lead one to think that the Supreme Court supports amateurism. This was a 9-0 ruling. This was a ruling by very conservative and very liberal justices, and some more in the middle. They all found the NCAA's arguments to be unpersuasive. And I think it invites the question of, why did the NCAA even petition the Supreme Court? I get it, we're playing hindsight, Tuesday morning quarterback, all of that, very true, but this was avoidable. The NCAA for years has latched on to a 1984 Supreme Court decision called the Board of Regents case, had nothing to do with college athletes. It was a case where the NCAA limited the number of broadcasts that a school could show, football broadcasts that a school could show on Saturdays. Nothing to do. And they also lost the case. Yet within that opinion, Justice Stevens wrote, well, when it comes to college athletes, we ought to defer to the NCAA. So the NCAA has latched onto that language. Well, and that language would have kept going, but for this case. Here, Justice Gorsuch said that case had nothing to do with college athletes. And moreover, as Justice Kavanaugh stressed, it's dicta, meaning it's not binding precedent. So the case that the NCAA has loved is now gone. It's there, but it's no longer the precedent, because the precedent will be the Alston ruling. So that's a big defeat for the NCAA. What does it mean going forward? It means others could use the Alston ruling to challenge rules. So let me give you an example. How about high school athletes when they're recruited? There are restrictions on what they can get from schools. Why not challenge those rules under the Alston ruling? There are restrictions on competition. These are rulings that affect the college enrollment academics of a prospective college student. It doesn't take an antitrust expert to come up with at least a facially plausible argument that those restrictions might be illegal too. This is going to open the door for more litigation. And I think the NCAA is going to have to think long and hard about what is its strategy going forward. Does it want to keep fighting these fights? How many fights does it have in them? At what point should conferences, and we've already seen conferences gain some discretion in what they can pay college athletes. Maybe we're going to see more of that. Maybe we're going to see what some would argue is a more appropriate system, where conferences that are very different, the Power Five conferences are very different from other conferences, where they change the rules on what's allowed. And there are some conferences where college athletes are more like the sort of romanticized view of college sports. They are college students who play a sport. And I will acknowledge this. I teach at the University of New Hampshire School of Law. I teach an undergraduate course, Sports Law Controversies, and you can be sure this will be on the syllabus. I have athletes who take that class. They are college students who play a sport. They're not going to make money. They're not going pro. Maybe the rules for them should be different than Trevor Lawrence and Zion Williamson. Why are they all grouped together? It's an odd mix. More than that, let's talk about name, image, and likeness, because it's still central. Then I'm going to get to questions. So what's going on with name, image, and likeness? We know that Congress has attempted but failed to pass a federal NIL statute that would allow college athletes to sign endorsement deals and sponsorships get paid to influence on social media, all of those things. Nonetheless, at least six states will have NIL statutes that go into effect on July 1, and there are another dozen that will have NIL statutes that take effect over the following year or so. So what does that mean? It means a conflict of law. First off, on July 1, NCAA member schools in those six states will have a choice. Either follow the state law or adhere to their contractual obligations to the NCAA. In either case, they're breaking the law, unless the NCAA takes action before July 1. Either contract law or a violation of a state intellectual property statute. So what does the school do? Well, it faces a tough choice, to put it mildly. Would the NCAA take action before then or after then? The NCAA, Mark Emmert, had sent an email that was first reported by the Associated Press, where he told schools, basically, get your act together, figure out name, image, and likeness, because it's coming. You know, this is sort of like the student who waits to take the Civ Pro study the last night before the Civ Pro test. Kind of hard to figure things out at the last minute. And keep in mind, the Ed O'Bannon case was filed a dozen years ago. It seems odd that we're waiting until the very last second to figure these things out. Nonetheless, it puts the schools in a tough spot. Will Division I, Division II, and Division III come up with rules for name, image, and likeness before July 1? Maybe, but that doesn't solve things, because those rules could contain restrictions that violate state law. So it's possible that an athlete in a state where a state law doesn't put, say, a fair market value restriction on his or her use of name, image, and likeness, and let's say the NCAA rules do, that would allow that athlete to have a cause of action under the state law against the school and the NCAA and the conference. The NCAA could also go to court before then. It could seek restraining orders. It did this before, back in the Miller case in the early 90s. So very briefly, in that case, it involved UNLV got into trouble with recruiting. The UNLV felt that it was unfair how they and their coach, Jerry Tarkanian, were treated by the NCAA. So the state and the governor, state passed a bill and the governor signed it, Governor Miller, that created due process protections for those that were investigated by the NCAA. I'm sort of summarizing it. You can read on Sportico more details. But the gist of it was that the NCAA sued saying, you are in violation of two areas of the U.S. Constitution. One is the contract clause that prevents states from interfering with the contractual relations of state entities, including member schools. And secondly, the Commerce Clause, because the NCAA, Nevada had created a patchwork problem where the NCAA couldn't administer one rule nationally, especially if other states came up with their own due process clauses, protections. And the NCAA won. Would the NCAA try that strategy here, arguing that name, image, and likeness is a violation of the Contract and Commerce Clause? Possible. It's a different story here, though. Here, the relationship is between the athlete and a third party, not with the school. So anyway, there's a lot going on, and I tried to summarize it in 15 minutes, and I went over. It's 3:16. So I'm now going to look at some of the questions, and I appreciate everyone listening in on this. And one question is, what decision the impact can have on black athletes and female athletes going forward? A great question. So, and this is something that I just should know, Ed O'Bannon, you can see behind me, Court Justice, which is a book that I wrote with Ed O'Bannon, where he talked about these issues, how, and this came up in last week's Senate hearing, where a number of college athletes spoke about these issues, where where those that are most disadvantaged by restrictions on amateurism, including, as discussed in the Alston case, and including name, image, and likeness, are students of color. And it doesn't mean it's intentional racism. Ed O'Bannon said it's not about that, but changing these rules ought to have the greatest impact on those who are most hurt by them, which would be students of color. So I think they would stand to receive the most. On women's sports, this is a more interesting, this is maybe a harder question to answer, because I think that Title IX analysis is going to be helpful going forward. But I can answer it briefly in saying that the Alston ruling says that schools can decide how much they want to pay for education-related expenses, right? That's the core of the opinion. They're going to have to follow Title IX when they do so. So they can't pay the football players, the men's basketball players, more money than the women athletes. So Title IX will still apply. With name, image, and likeness, it also applies, though maybe in a different sense. Schools are not going to be directly involved with NIL because the relationship is going to be between the player and a third party. So the sneaker company, the social media influencing company. But the school can get in trouble if it weighs in on these issues. So if it starts to provide advice, or if it contracts to a third party, which we're seeing some schools do with name, image, and likeness, and then that third party doesn't follow Title IX. I could see Title IX litigation being brought there. So the short answer, and I think this is from Charles, is that with Title IX, it's a complicated topic that's hard to sort of, answer definitively in this forum. And there are Title IX lawyers who are fantastic in looking at these issues. But I would say that the brief answer is that Title IX still applies, and it will still be an issue going forward. And whether it's name, image, and likeness or education-related benefits, schools are going to have to make sure they provide those benefits and those rights in a way that promotes gender equity. Let's see here. Will the authorization of NIL payments sufficiently undercut the argument that the public demands amateur athletics from colleges such that a new challenge might strike down amateurism entirely? Yeah, I actually think there's a playbook here for lawyers and college athletes to take on amateurism more broadly, an attack on athletic-related rules. Mike Zarin, who's an attorney, he's also works for the Celtics, but he had a great tweet earlier saying the NCAA is, and I'm summarizing, so this is not a direct quote, the NCAA is saved by the manner in which this litigation arose, because the litigation at the end didn't challenge athletic-related benefits. But that doesn't mean the Supreme Court supported the NCAA's use of those restrictions. It simply said that's outside the scope of the ruling. Well, someone could bring a case on those, whether it's a college athlete, whether it's a high school athlete. It wouldn't surprise me to see more litigation brought, and you can bet that in the first paragraph, language from Justice Gorsuch and maybe language from Justice Kavanaugh will be cited. Certainly Justice Kavanaugh's language is more explosive because it's really a sack of amateurism. He's basically saying this whole system is a scheme, in so many words, that there's blatant price fixing. That language is going to be used. It's not as if these rulings come and go. Look at the Board of Regents case that I referenced earlier. It's been cited all the time by the NCAA. Now we're going to see the reverse. We're going to see lawyers for athletes citing Alston. What are the prospects for a legislative solution to this? An antitrust exemption to permit negotiation of college athlete compensation and or security arrangements. I'm very skeptical. It's a great question. I'm very skeptical that Congress is going to support an antitrust exemption for the NCAA and its member schools. First of all, look at it this way. Why? Why exempt any entity from antitrust law? Antitrust law, we just saw the Supreme Court hold, and I don't mean to bash the question, but the Supreme Court just said what the NCAA, the Supreme Court just said what the NCAA is doing violates antitrust law. Why are we going to give them something, right? If anything, maybe they should be held to greater scrutiny, you could argue. But more than that, to win an antitrust case is actually very hard. Antitrust law is pretty deferential. What the NCAA was fighting against was a fairly permissive form of review. It's called rule of reason. Rule of reason essentially says rules that are more pro-competitive than anti-competitive are lawful, and those that are more anti-competitive than pro-competitive are unlawful. It's actually really hard to win an antitrust case. There's data on this. So the idea that the NCAA is going to be subject to antitrust law hardly means that they're going to be violating antitrust law. All they have to do is come up with reasonable rules, reasonable restrictions. And it's up to them to figure out what those are. But I would say taking away antitrust law in the wake of a 9-0 ruling where they were found to violate antitrust law, to me, strikes me as the wrong approach. Compliance directors at schools are due for a raise, I think. I'll tell you who's due for a raise. Yeah, the compliance directors. How about the compliance officers? How about those below the directors? Lots of compliance. This is going to be the toughest period yet for college compliance officers. And these folks do great work. Many of them are lawyers, not all, but many of them are lawyers. And I will say I have a number of students who have gone on to be outstanding compliance officers at schools across the country. They are in for a rough patch. Why? First of all, the NCAA is going to have to change its rules after Alston, and they're not going to know, the compliance officers aren't going to know what those rules are. And then remember, July 1 is coming. It's 10 days away. What's going to happen on July 1? Say you're a compliance officer at a school and an athlete says, hey, I want to go sign an endorsement deal. Can you stop him or her on July 1? What are you going to say? You're going to say, well, I don't know what to do because if I let you do that, I'm telling my school to violate its contractual obligation to the NCAA. This is a tough period. Yeah, they've been due for a raise for a while, okay? This isn't new. For those that do that work, they are underpaid in my view, and they are due for a bigger raise now. In the Title IX conversation, it has been thought-provoking to see some schools provide, for example, to basketball teams, but not athletes by rule. Yeah, so with Title IX, the days, first of all, that's wrong. You're right that it happens, but it's wrong under at least the spirit of Title IX. Title IX is about gender equity, not only in opportunity. It's not just about how many slots, how many women athletes, how many men athletes, and what is the proportion of undergraduate students. There's that, but there's also this. You have to treat them relatively equally. And I don't know if that always happens. I think it doesn't happen. right? Look at Sedona Prince. That was not a school. That was the women's basketball tournament when she took the photo of the the gym for the women's team, the women's players, and the men's team has a world-class facility. That kind of stuff is wrong morally, and I also think it's wrong in terms of the law. But with Alston, the added discretion that schools are going to have, they've got to use it in a way that complies with Title IX. I know we're running out of time, so I'm going to try to run through these. As an attorney and educator, what is your best advice, plan of action for the scholarship athlete, university, Division I athletics? How can they best position themselves to take advantage of this ruling? So Professor Gleiser, who's a terrific sports law attorney and professor at SMU, he's asking, what advice do you have for these scholarship athletes? What are they supposed to do when July 1 comes? What are they going to do when the fall comes? In fact, some of them are already on campus. So it's not as if this is a fall semester issue. This is actually a present day issue. What I would say to them is wait for clarity from the athletic department, because the athletic department is going to be under tremendous pressure to quickly put together a set of reasonable rules regarding name, image, and likeness, and now regarding these education benefits. I would say wait, and I realize waiting is sometimes not the best answer, but waiting often leads you to a position where once the rules are clear, you're less likely to run into problems later on, headaches later on. And if you're a college student, if you're a college athlete, you're already really busy, right? You're taking a full load of classes, plus you're spending many hours a week on sports. I would be a little bit patient. I would talk to your compliance officer and get from him or her a timeline, but I wouldn't rush so quickly just because everything is in flux right now. I know not all are going to do that. And I know I'm speaking to a generation of athletes that grew up on social media where things happen instantly. It's a different generation. I realize that. But I would also say sometimes just wait a few weeks, wait a month. You don't have to do everything the first day. You might end up saving yourself some headaches later on. How does this affect companies like Open Doors and others that are set to profit from the NIL space? I don't think it does, at least not directly, because those NIL statutes still go into effect on July 1. This case is about, and I know I'm almost out of time, so I'm going to wrap up with this. This case is about federal antitrust law and the NCAA and its member schools violating it by constraining what athletes can get for education-related expenses. NIL falls under a different category of law, intellectual property, right of publicity. That continues. It's coming July 1. Even if the NCAA won this case, it's coming July 1. So those companies are in the same position they were yesterday. But that's also not necessarily an ideal position, because I'm sure they would prefer that Congress have come up with a national rule rather than a state-by-state approach, or that the NCAA comes up with the rule itself. But the problem there is that that rule could conflict with state law. So, I hate to say this, the story doesn't end happily. July 1 is coming, and there will be conflict on that day. So it looks like I'm out of time. I really appreciate all of you participating in this forum. I hope it was helpful, and I'm sure we're going to have many more of them. Keep reading Sportico. Keep joining us for our fast takes.